of a witness, you may consider evidence of a statement by or conduct of the witness on some prior occasion that is inconsistent with present testimony. Evidence of any prior inconsistent statement or conduct should be considered only to test the believability and weight of the witness's testimony. In the case of the defendant, however, evidence of any statement the defendant may have made may be considered by you for all purposes. In this case, you have heard evidence as to the general character and character of honesty of the defendant. You should consider such evidence with all the other evidence in the case in determining whether or not the prosecution has proven the defendant's guilt beyond a reasonable doubt. During this trial, I have ruled on objections to certain exhibits and testimony. You must not concern yourself with the reasons for these rulings, since they are controlled by rules of evidence. By admitting into evidence testimony and exhibits as to which the objection was made, I did not intend to indicate the weight to be given such testimony and evidence. You are not to speculate as to possible answers to questions I did not require to be answered. You are to disregard all evidence and statements of attorneys that I have ordered stricken or have told you to disregard. During the testimony of some witnesses, the parties introduced demonstrative exhibits in the form of charts and summaries. This information was presented to assist you as an aid in your understanding of the witness's testimony and to help explain the facts disclosed by the records, other documents, testimony, and other evidence that was received during the trial. If any chart or summary is not consistent with the facts or figures shown by the evidence in this case, as you may find them, you should disregard the chart or summary and determine the facts from the underlying evidence. Brooklyn Center Police Department policies are not criminal statutes. An alleged violation of a policy is not a crime. In this case, defendant has been charged with 2 offenses. You should consider each offense and the evidence pertaining to it separately and in any order you wish. The fact that you may find the defendant guilty or not guilty as to one of the charged offenses should not control your verdict as to any other offense. If I do not define a word or phrase that is used in these instructions, you should apply the common ordinary meaning of that word or phrase. To cause death, causing the death, or caused the death means that the defendant's acts or act were a substantial causal factor in causing the death of Daunte Wright. The defendant is criminally liable for all the consequences of her actions that occur in the ordinary and natural. Those consequences brought about by one or more intervening causes, if such intervening causes were a natural result of the defendant's acts. The fact that other causes contribute to the death does not relieve the defendant of criminal liability. However, the defendant is not criminally liable if a superseding cause caused the death. A superseding cause is a cause that comes after the defendant's acts, alters the natural sequence of events, and is the sole cause of a result that would not have otherwise occurred. Great bodily harm means bodily injury that creates a high probability of death, that causes serious permanent disfigurement, or that causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily harm. The defendant is charged in count 1 with manslaughter in the first degree in connection with the death of Daunte Wright. Under Minnesota law, whoever, while committing a misdemeanor or gross misdemeanor offense with such force and violence that the death of or great bodily harm to any person was reasonably foreseeable, causes the death of another, is guilty of manslaughter in the first degree. The elements of manslaughter in the first degree while committing a misdemeanor are First, the death of Daunte Wright must be proven. Second, the defendant caused the death of Daunte Wright. Third, the death of Daunte Wright was caused by the defendant's committing the crime of reckless handling or use of a firearm. There are two elements of reckless handling or use of a firearm. First, the defendant recklessly handled or used a firearm. A person acts recklessly if, under the totality of the circumstances, she commits a conscious or intentional act in connection with the handling or use of a firearm that creates a substantial and unjustifiable risk that she is aware of and disregards. Second, the defendant handled or used the firearm so as to endanger the safety of another person. It is not necessary for the state to prove any intent on the part of the defendant to kill anyone. Fourth, the defendant committed the crime of reckless use or handling of a firearm with such force or violence that the death of another person or great bodily harm to another person was reasonably foreseeable. Fifth, the defendant's act took place on or about April 11, 2021 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty. If you find that any element has not been proven beyond a reasonable doubt, the defendant is not guilty. The defendant is charged in count 2 with manslaughter in the second degree in connection with the death of Daunte Wright. Under Minnesota law, whoever by culpable negligence whereby she creates an unreasonable risk and consciously takes a chance of causing death or great bodily harm to another person causes the death of another is guilty of manslaughter in the second degree. The elements of manslaughter in the second degree are: first, the death of Daunte Wright must be proven. Second, the defendant caused the death of Daunte Wright by culpable negligence, whereby the defendant created an unreasonable risk and consciously took a chance of causing death or great bodily harm. Culpable negligence is intentional conduct that the defendant may not have intended to be harmful, but that an ordinary and reasonably prudent person would recognize as involving a strong probability of injury to others. It is not necessary for the state to prove any intent on the part of the defendant to kill anyone. Third, the defendant's act took place on or about April 11, 2021 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty. If you find that any element has not been proven beyond a reasonable doubt, the defendant is not guilty. With respect to any alleged use of a firearm, Minnesota law provides that no crime is committed and a police officer's actions are justified only when the police officer uses deadly force in the line of duty when necessary to 1. Protect the police officer or another from apparent death or great bodily harm, 2. Effect the arrest or capture or prevent the escape of a person whom the police officer knows or has reasonable grounds to believe has committed or attempted to commit a felony involving the use or threatened use of deadly force, or 3, effect the arrest or capture or prevent the escape of a person whom the police officer knows or has reasonable grounds to believe has committed or attempted to commit a felony if the police officer reasonably believes that the person will cause death or great bodily harm if the person's apprehension is delayed. Deadly force means force which the police officer uses with the purpose of causing, or which the police officer should reasonably know creates a substantial risk of causing death or great bodily harm. In determining whether the defendant should reasonably have known that the force she applied created a substantial risk of causing death or great bodily harm, you are not to consider the defendant's underlying intent or motivations. It is not necessary for the state to prove that the defendant intended to cause death or great bodily harm, or believed that such harm would occur. The defendant need only have acted with intent to use force and prove that a reasonable person in the defendant's position would have foreseen a substantial risk of causing death or great bodily harm. As to each count or defense, the kind and degree of force a police officer may lawfully use in protecting themselves or another, effecting arrest or capture, or preventing escape is limited by what a reasonable police officer in the same situation would believe to be necessary. To determine whether or not the actions of the police officer were necessary, you must look at those facts known to the police officer at the precise moment she acted with force. The reasonableness of the particular use of force must be judged from the perspective of a reasonable police officer on the scene, rather than with the benefit of hindsight, taking into consideration the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. The defendant is not guilty of a crime if she used deadly force as authorized by law. To prove guilt, the state must prove beyond a reasonable doubt that the defendant's use of deadly force was not authorized by law. In this case, you have heard testimony about whether the defendant's apparent decision to use a taser was reasonable or appropriate. The statutes of Minnesota provide that a police officer is authorized to use reasonable force in the line of duty in 1. Effecting a lawful arrest, 2. Executing legal process, 3. Enforcing an order of the court, or 4. Executing any other duty imposed upon the officer by law. You are instructed that executing a lawful arrest warrant is a duty imposed on police officers by law. The kind and degree of force a police officer may lawfully use in executing the police officer's duties is limited by what a reasonable police officer in such a situation would believe to be necessary. Any use of force beyond that is not reasonable. To determine whether or not the actions of the police officer were reasonable, you must look at those facts known to the police officer at the moment the police officer acted with force. The reasonableness of the particular use of force must be judged from the perspective of a reasonable police officer on the scene, rather than with the benefit of hindsight, taking into consideration the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. Whether the defendant's apparent decision to use a taser was reasonable or appropriate is not a defense to the charges in this case. Now, members of the jury, I'm going to give you some additional instructions to guide you in your deliberations and with respect to the exhibits. But at this time, the attorneys will be making their final arguments to you. And the state may proceed first.
Thank you, Your Honor. If I may have a moment, Your Honor.
Yes.
Members of the jury, the defendant told you her sons will be home for the holidays. But you know who won't be home for the holidays is Daunte Wright. Daunte Wright's parents, Katie and Aubrey Wright, will have an empty seat at their table this holiday season because the defendant shot and killed him on April 11th of this year. He was just 20 years old. He had a baby boy of his own. And that's why we're here today. We're here because the defendant, Kimberly Potter, a 26-year veteran of the Brooklyn Center Police Department, pulled the wrong weapon, and she shot and killed Daunte Wright. And at the heart of it, this case is very simple, members of the jury. It's a case about the defendant's reckless handling of her firearm, and it's about her culpable negligence. It's about what she did on April 11th. She drew a deadly weapon, she aimed it, she pointed it at Daunte Wright's chest, and she fired. Now, the defense will tell you that Daunte Wright is somehow to blame in causing his own death. But make no mistake, we're here because of the defendant's actions, not Daunte Wright's. She knew she had a loaded gun on her duty belt, a gun that she carried every single day on the job. She carried it on the right side every day for 26 years. And that's the weapon she used. That's the weapon she drew. That's the weapon she pointed. And that's the weapon she fired. Members of the jury, that's culpable negligence, and that's reckless handling of a firearm, resulting in death. This case is about the defendant's rash and reckless conduct. It's not about her being a nice person or a good person. Even nice people have to obey the law. It's not about the smell of marijuana. It's not about a gross misdemeanor warrant. It's not about an order for protection. And it's certainly not about anyone being dragged. No one was dragged. No one was almost dragged. And how do you know that? Well, you know that from what the defendant said herself on April 11th. You know from her own reaction to what she had done and from what she told you in court. What this case is really about is about an officer who mishandled her firearm. That's why we're here. And even if you take the defendant's word for it, she admits that's what she did. She told you in court she knew it was wrong. And she knew from the very beginning, from the things that she said. She was no rookie. It wasn't her first day on the job. She was an FTO, a field training officer. She had 26 years of experience on the street. Every year, for 26 years, she was trained on how to use her gun and how to use it safely. And every year, for 26 years, she was trained on use of force. And every year, for 19 years, she was trained on using her taser and using that properly. Every year, she saw the PowerPoints. Every year, she was told about the risk of weapon confusion and that pulling a gun instead of a taser could kill somebody. Every year, she signed the paperwork acknowledging the risks. And all that training and all that experience shows she shouldn't have done what she did. All that training and all that experience shows that she was aware of the risks associated with her weapons. She was aware of all kinds of risks. The risk of incapacitating a driver behind the wheel, the risk of collateral injuries, and the risk of drawing and firing a gun instead of a taser. And her conduct and her choices on April 11th show that she disregarded all those risks. Now let's talk about what happened on April 11th and what she did. And the videos show exactly what happened and what she did. This traffic stop on April 11th was nothing out of the ordinary. So ordinary, in fact, that the defendant told you herself she wouldn't have even stopped this car. She wouldn't have even stopped Daunte Wright if she had been alone for the air freshener and the expired tabs. But they did. She and Officer Lucky pulled this car over. And the defendant had initially observed the interaction between Officer Lucky and Daunte Wright. When he first approached, she was hanging out toward the back. She told you it appeared to be a fine conversation. Officer Lucky wasn't in any distress. And then in the squad car, they learn about this ex parte order for protection and a gross misdemeanor warrant. And Sergeant Johnson shows up and they decide to arrest Daunte Wright on that misdemeanor warrant. Daunte Wright was unarmed. He had no gun. He had no weapon, and he posed no threat to those officers. Now, when they approach together to arrest Daunte Wright, the defendant has her hand on her gun. Now, Sergeant Johnson does not appear to be particularly concerned at all. He puts his hand casually on the car. They approach. She tells Officer Lucky, just have him step out, giving Officer Lucky direction, what to do, how to arrest the driver. Sergeant Johnson and Officer Lucky tell Daunte Wright he's under arrest, and she adds, "You've got a warrant." And when she says that, that's when Daunte Wright pulls away. That's when he tries to get back in the car. Now let's walk through what the videos show. The defendant approaches. She grabs Daunte Wright's right arm with her right hand, uses her left hand to retrieve a piece of paper. This piece of paper, an insurance card. She takes that piece of paper into her left hand and switches it to her right. She reaches for Daunte Wright. She approaches the driver's door from the rear before she would have any view or idea of what Sergeant Johnson is doing on the inside. And you can see, ladies and gentlemen, that Daunte Wright had taken down that air freshener. She approaches from behind Officer Lucky. She moves around him to the left, but still behind him. Now Daunte Wright gets in the car. She's still behind Officer Lucky. And if she even caught a glimpse of Sergeant Johnson in that frame, she wouldn't have gotten a good look at him. She reaches with her left hand for Daunte Wright's left hand with that piece of paper still in her right hand. She's still behind Officer Lucky. She still doesn't have a view of what's going on in front of her. Now, after she reaches for Daunte Wright, she takes that piece of paper from her right hand and switches it back to her left hand. She does this to free up her gun hand, her right hand. Now, 201-55 is the first time that the defendant says, "I'll tase you." She says that, and she's already decided to pull a weapon. And you can see it come into frame at 201-56. She pulls this weapon while looking down at Daunte Wright with this piece of paper in her left hand. She draws that gun. She points it. She holds it in front of her face, looking down at Daunte Wright, pointing this loaded Glock at his chest, aiming it, tracking his movements. Now at 201-58 is the second time she says, "I'll tase you," while still pointing that gun at Daunte Wright, while still tracking his movements, not Sergeant Johnson's. Now at this point, Officer Lucky has had some success in trying to remove Daunte Wright from the vehicle. You can see that Daunte Wright's left leg is out of the car. The defendant continues to point this gun at Daunte Wright's chest. And at 202-00 is when she says, "Taser, taser, taser." And at that point you can see that's when Officer Lucky lets go. And Daunte Wright is able to get both of his feet in the car by the pedals. And at 202-01, while she's still saying, "Taser, taser, taser," she presses the trigger and shoots. She shoots Daunte Wright in the chest, and that cartridge casing that you see is circled on the screen ejects right into Officer Lucky's face. It bounces off his face. You can see Officer Lucky's expression after being hit with the cartridge casing in the face as the defendant shoots Daunte Wright under his arm and directly in front of his face. Members of the jury, this may be one of the first frames where you can see Sergeant Johnson. This is Sergeant Johnson as he's backing out of the vehicle after the defendant has already shot Daunte Wright in the chest. You see the top of his head, you don't see his face, and he's backing away after the defendant has already shot Daunte Wright. She shoots him, and she reaches back into the car herself with her left hand, with that Glock still in her right hand. Then she puts it back in her holster. She grabs Daunte Wright's left arm. And she still has that piece of paper in her left hand. Now, not only do you have the defendant's body-worn camera, but you also have Sergeant Johnson's to review. And during that same time frame, let's look at what Sergeant Johnson was doing. He's got his feet on the ground. He approaches the passenger side of the car. He opens the door. again with his feet on the ground. He puts his left hand in at his feet, his shoulders, his hips, his body outside the car, his feet planted firmly on the ground. He reaches over Elena Albrecht Payton, pushes on the shifter so that Daunte Wright can't go anywhere. Sergeant Johnson was clearly not afraid of being dragged. He never said he was scared. He didn't say it then, and he didn't testify to it in court. He puts his hand on Daunte Wright and is able to pull Daunte Wright's right arm all the way across the passenger side of the car, where he is, outside, almost outside, across the passenger side. He had, at this point, successfully prevented Daunte Wright from driving the car, and he had done that successfully up until the point where the defendant shot him. He was clearly not worried about it at all, and he didn't even remember the line that the defendant fed him. So it clearly was not so significant to him. But after the defendant shoots her gun, and after Sergeant Johnson had chosen to engage and chosen to disengage, he stands up, he steps back, and he shuts the door behind him. Ladies and gentlemen, members of the jury, Sergeant Johnson had the time and the forethought to protect Elena Albrecht Payton from what the defendant had just done. She shot a driver and sent an unguided hazard down the road. The defendant didn't save Sergeant Johnson's life. Both Elena Albrecht Payton and Sergeant Johnson were in the line of fire. If anyone saved Sergeant Johnson's life, it was Daunte Wright when he took a bullet to the chest. And you saw Officer Lucky. He was so close that that cartridge casing bounced off his face. That's how close he was. Members of the jury, safe handling of a firearm does not include firing it into a car with 4 people directly in harm's way. In addition to all the other people at risk on that public street, including the Lundgrens, who just happened to be driving by. When it comes to risk, every single traffic stop where an officer pulls over a car and approaches comes with some risk. There's always risk that a driver could take off. Every time an officer reaches into a car or into a window to take a license or hand over a ticket, there's some risk that the driver could take off or flee. There's some risk of being hit by the car, but that doesn't make it an actual threat. It doesn't mean that someone is likely to be dragged, and it doesn't mean that every time an officer approaches a driver, she can shoot them dead. That would be absurd. It would be absurd even if a fellow officer looked scared, which the defendant, mind you, would not have even been in a position to be able to see. Carrying a badge and a gun is not a license to kill. You don't get to shoot someone when things don't go according to plan. I'd like to take a little time to talk about the charges in this case. The judge has given you some instruction. There are two charges here: manslaughter in the first degree, manslaughter in the second degree. Here we have a highly experienced, highly trained, 26-year veteran of the police department who drew her gun, who pointed it at Daunte Wright for almost 6 seconds. She pulled the trigger and she shot him in the chest. She did all this all without recognizing or confirming that she had this gun in her hand. And she did those things despite her awareness of all of those risks, all kinds of risks, including the risk of weapon confusion. That's reckless, and it's culpably negligent. And these are manslaughter charges, members of the jury. They're not murder charges. They are not intentional crimes. They're not crimes of intentional homicide. No one is saying that the defendant meant to kill Daunte Wright. I'm going to take some time to go over the elements. The judge obviously has instructed you. Some of these things are not so much in dispute, but bear with me. I'm going to take some time to cover what the evidence shows and how that supports each of these counts. So for manslaughter in the first degree, the elements are: 1, the death of Daunte Wright must be proven. Well, that's not really in dispute. Members of the jury, you heard from the paramedics. He was declared dead on scene. 2, the defendant caused the death of Daunte Wright. That's clearly proved as well. You heard from Dr. Jackson. You saw the autopsy photos. You saw the damage to Daunte Wright's heart when that hollow point bullet blew through it. He would have been unconscious within 10 to 15 seconds, and he would have been dead seconds thereafter. And you heard Dr. Jackson tell you the cause of death here was not a vehicle accident, it wasn't marijuana, it was a gunshot wound to the chest. Third, and this is the one that I'll spend some time on, the death of Daunte Wright was caused by the defendant's committing the crime of reckless handling or use of a firearm. And there are two elements of reckless handling or use of a firearm. First, the defendant recklessly handled or used a firearm. You have a definition of that. A person acts recklessly if under the totality of the circumstances she commits a conscious or intentional act in connection with the handling or use of a firearm that creates a substantial and unjustifiable risk that she is aware of and disregards. Let's talk a little bit about that one for a second. An intentional act or intentional conduct, as you'll see in the later instruction, just means some voluntary act, not a reflex. Some choice you make to act or move your body in a certain way, like putting your hand on a weapon, like putting a piece of paper in your other hand, unholstering a weapon, pulling a weapon, pointing that weapon, pulling the trigger of that weapon. Each and every one of those things, in, of, and by itself, is an intentional act. Let's talk a little bit about substantial risk. Well, pulling, pointing, and shooting a firearm without confirming what it is and what you're doing with it clearly creates a substantial risk of harming someone with that firearm. And she was trained to safely handle that firearm, and she was aware of the risk of killing someone with that firearm. Members of the jury, she told you herself, I could kill someone if she ever used that firearm. She disregarded that risk. And her actions show that she recklessly handled that firearm in pulling that gun with her finger on the trigger, pointing it and aiming it at Daunte Wright's chest, pulling the trigger, shooting into the car. Her statements also show you She has an awareness of that risk. So what else did she tell you? She told you last week that she wouldn't unsnap her gun holster on the way to a car because she's only 5'3" and she could lose it in a fight. Whether or not you believe that to be the case, whether or not she actually unsnapped her holster on the way to the car, doesn't really matter. What matters is that she acknowledges that she knows that she carries a gun on her hip every day, and that there are risks associated with even carrying that gun, let alone using it. She knows it's dangerous. It's dangerous to use, and it's dangerous to lose. And she admitted that. It's obvious. It's a deadly weapon. You can use your common sense. But it also shows her awareness of the risks of that firearm ever being taken out of the holster at all, by herself or anyone else. It's a loaded Glock with a round in the chamber and no external safety. Now, in addition to that risk, officers are warned about that risk of what they call weapon confusion, pulling and firing the wrong weapon. You heard, members of the jury, that weapon confusion is well known in the entire policing industry. It's warned about in trainings, it's talked about in policies, and it was known by the defendant. She was in the classes and she told you she paid attention. She was aware of the risks of pulling her gun instead of her taser and shooting someone. And she disregarded those risks. Blindly pulling any weapon out of your duty belt while knowing that you're armed with a loaded gun every day is reckless. And it's consciously taking that risk. And you heard that even former Police Chief Gannon acknowledges, yeah, officers should know when they have their gun in their hand. Let's talk about this second part of the reckless handling instruction. The defendant handled or used the firearm so as to endanger the safety of another person. Well, drawing a firearm, pointing it at someone's chest, pulling the trigger, all of that is clearly dangerous. It was dangerous to Daunte Wright, and it was so dangerous that it in fact killed him. It was also dangerous to everyone around him. To Elena Albrecht Payton, to Officer Lucky, to Sergeant Johnson as well, who were all potentially in harm's way. Fourth, the defendant committed the crime of reckless use or handling of a firearm with such force or violence that the death of another person or great bodily harm to another person was reasonably foreseeable. If you draw the gun, your gun, and point the trigger, or if you point the gun and pull the trigger, it's clearly foreseeable that you can hurt or kill somebody. And that's actually what happened here. And the defendant herself told you that over the course of her 26-year career, she never fired her weapon in real life because she knew that I might kill somebody. So what does that show? It shows awareness of foreseeable risk. It's clearly foreseeable that you can kill someone when you mishandle your firearm and pull the trigger. And it was foreseeable to her. Fifth, the defendant's act took place on or about April 11th, 2021 in Hennepin County. That's not really in dispute. Brooklyn Center is in Hennepin County. All of this happened on April 11th. But I'd also like to point out, as I said before, that it is not necessary for the state to prove any intent on the part of the defendant to kill anyone. We don't have to prove it. That's not what this case is about. Let's talk about manslaughter in the second degree. The death of Daunte Wright must be proven. That's the same. I'll come back to the second element. The defendant's act took place on or about April 11th in Hennepin County. That's the same too. But let's talk a little bit about the second element in culpable negligence. The defendant caused the death of Daunte Wright by culpable negligence, whereby the defendant created an unreasonable risk and consciously took a chance of causing death or great bodily harm. And then culpable negligence is defined for you. Intentional conduct, that's the same thing that we talked about before, voluntary act, not a reflex. That the defendant may not have intended to be harmful, but that an ordinary and reasonably prudent person would recognize as involving a strong probability of injury to others. Members of the jury, she made no effort to protect against shooting and killing someone. And she took specific actions that put Daunte Wright and everyone else around him at risk. An ordinary and prudent person would not have drawn a weapon, held it for more than 5 to 6 seconds, aimed it, and pulled the trigger, all without recognizing or confirming what was in their hand. The defendant created an unreasonable risk of harm to Daunte Wright and everyone else around him by doing what she did. Her actions created the risk. She put that into motion. She didn't have to intend to harm anyone. She didn't have to intend to kill Daunte Wright. But that's what she did. She consciously took a chance of causing death or great bodily harm by pulling a weapon and firing it without giving it a second thought. She knew she had a loaded Glock on her duty belt, loaded with hollow point rounds, a gun with no external safety, like we discussed, and all you had to do was pull the trigger. Not only did that have a strong probability of hurting or injuring someone, she actually killed someone. Responsible gun owners know to secure their firearms, to lock them up, to keep them safe, to store them securely. Responsible gun owners know the importance of safely handling and using their firearms. They're dangerous. You gotta be safe. Responsible officers know not to blindly draw their weapons and press the trigger. And responsible officers are acutely aware of the risks of getting it wrong. Members of the jury, we're here because this was entirely preventable, totally avoidable. If she had followed her training and paid attention to what she was doing and considered the risk. And she was aware of the risk. She appreciated the risk. And what's the best evidence of that? Her own admissions. What she said afterward, what she said in court. But on April 11th, she said, I shot him. I pulled the wrong fucking gun. I'm going to prison. I killed a boy. Let's talk a little bit about deadly force. You have a long instruction on this, but I just wanted to touch on it briefly. Deadly force is the force that was used here. It's the force that was used when the defendant shot Daunte Wright with her gun. Even if she didn't intend to use deadly force, she intended to use force. And that's clear from what she said and from what she did. And a reasonable person in her position would have foreseen a substantial risk, again, of death or great bodily harm from her actions. Reasonable people know that guns kill. And if you pull one and press the trigger, people can die. You don't blindly pull weapons and pull the trigger without being aware of that risk. That's common sense. So as far as this instruction, the defendant need only have acted with intent to use force, so even if she just intended to use a taser, and prove that a reasonable person in the defendant's position would have foreseen a substantial risk of causing death or great bodily harm. We just discussed that. And as to each count or defense, the kind and degree of force a police officer may lawfully use in protecting themselves or another, effecting arrest or capture, or preventing escape is limited by what a reasonable police officer in the same situation would believe to be necessary. When you're arresting someone, you still have to act reasonably. A reasonable police officer would not believe it to be necessary to use deadly force in these circumstances. What do reasonable officers believe? Well, they believe they shouldn't use unnecessary force. And here, deadly force was entirely unnecessary. And if you look at what Sergeant Johnson and Officer Lucky did before the defendant stepped in, they were using a proportional amount of force to address the situation. And even the defendant herself acknowledges what they were trying to do. They were just trying to stop him from getting away. They were not responding to any real threat. And how do you know that, members of the jury? It's evidenced by the videos. The last line that's highlighted here is to determine whether or not the actions of the police officer were necessary, you must look at those facts known to the police officer at the precise moment she acted with force. Go back to the videos, members of the jury. You can see what happened and what the defendant would have actually been able to see. But even when she testified before you, the defendant herself acknowledged that she didn't think deadly force was appropriate. She acknowledged it was unreasonable. And she acknowledged that shooting him was not warranted. But that's exactly what she did. That's the force she used. She used deadly force. She put a bullet through his heart. She killed him. And her statements are admissions that established that she was reckless and culpably negligent in using deadly force against Daunte Wright. Because she knew it was unreasonable, and she knew it was unwarranted, and she did it anyway. She put it all in motion despite all the risks. It's her hand, it's her gun, it's her actions. Members of the jury, you also have an instruction on non-deadly force. That's not really an issue when it comes to the charges in this case. It's not the force that was used here, and you'll see that it's not a defense to the crimes that are charged. And that's what's highlighted at the bottom. But on the topic of the taser, it's worth noting that you heard from Seth Stoughton, and he had pointed out that even if she had used a taser, it would have been inappropriate under the circumstances, where she could, and ultimately did, disable the driver of a vehicle, and which could, and ultimately did, injure other people, like Elena Albrecht Payton, like the Lundgrens. That's why those policies exist, members of the jury. That's why you don't tase a fleeing suspect. That's why you don't tase the driver of a vehicle. So what's the point of all that evidence about proper use of a taser? Well, it goes to show that even the decision to use a taser was not a wise one. It goes to show that she made a series of bad choices that led to her shooting and killing Daunte Wright. It goes to her disregard of all the risks. Members of the jury, this was no little oopsie. This was not putting the wrong date on a check. This was not entering the wrong password somewhere. This was a colossal screw-up. A blunder of epic proportions. It was precisely the thing she had been warned about for years, and she was trained to prevent it. It was irreversible, and it was fatal. Members of the jury, the people involved in this case happened to be the defendant's police family, is what she called them. The people who knew the defendant well, who know her well. Some have worked with her for years and years and years. Some have grown very, very close to her, including her own direct supervisor, who was Sergeant Johnson, whom she referred to as a rock star. When trouble comes, it's family that supports you unconditionally. Sticking by each other, for better or for worse, is what makes family family. The same thing appears to apply to the defendant's police family. The defendant has found herself in trouble, and her police family has her back. The state doesn't get to choose who the witnesses to a crime will be. But relationships to the parties is something you can consider. It's in your instructions when evaluating the testimony of any witness. And like with any family, often the clearest, most objective view comes from outside that family unit. An unbiased, reasonable, outside perspective. Outside the emotional bonds that tie family together. Keep in mind, members of the jury, that Commander Grunig and former Chief Gannon, they brought in the BCA to investigate this case, to make sure there was an independent review of what happened on April 11th and what the defendant did. Why do that? To avoid conflicts of interest, to avoid bias, to ensure independence and transparency. You saw for yourselves why. How can we ask officers who've known and liked the defendant, Kimberly Potter, for years, and who have been a part of her police family for decades, how can we ask them to independently assess what happened on April 11th? Self-review doesn't always work, and your common sense will tell you that. And I'm sure most Brooklyn Center police officers would have preferred to not have to be here to testify before you, but they did, and they had to. But the further away you get from the bias of a close relationship with the defendant, other officers, if you look at experts like Seth Stoughton, and even the defense experts, the clearer things become, the farther you move away from outside that family unit. You as jurors are in the best position to evaluate the evidence independently, without prejudice and without bias to any party. You're not beholden to the police department, you're not beholden to the defendant, and you're sure not beholden to the state of Minnesota. Your job is to fairly and impartially consider the evidence and the charges in front of you. That is all we're asking you to do here. And like I said earlier, this case is pretty simple. It's about the defendant's reckless handling of a firearm and her culpable negligence. It's about what she did. It's about her killing Daunte Wright. And what happened in this case is captured on video, and you're entitled to rely on your common sense. Don't speculate. Don't get sucked down that rabbit hole of hypotheticals and misdirection. What ifs and could haves are not the law, and none of that changes what actually happened here. What the lawyers say is not evidence. And you have an instruction on that. Even if we bang on the table and yell and stomp our feet, still not evidence. And anything we say doesn't change what actually happened in this case. Your job is to look at the evidence, to use your common sense, and apply the law. And how are you going to do that? You can do that any way you like. You're the jury. But the videos are an important part. You can go back to the videos. You can play them. You can rewind them. You can pause them. There are several videos you can review. And you'll have them on a laptop with all the other exhibits in this case. You'll also have the gun and the taser back there when you deliberate. They will be made safe for you, of course. The ammunition will be separate from the gun, but you'll be able to hold the taser and hold that firearm to compare those features, to get a feel for the two, and to get a sense of all those differences that you heard about in court, and see for yourselves how different they really are. And you'll also have those exhibits that are the training materials and the policies. And why are those policies important? Well, of course, a violation of policy in, of, and by itself is not a violation of law. You have an instruction on that. But the policies are important because they show what the standard of practice is, what the officers are expected to do as part of their jobs, what they're expected to know, what they're expected to do and not do. They include the things to consider in deciding to use force and how much force to use. And importantly, they show that the police industry as a whole has been aware of and has taken all kinds of steps to address and prevent things like weapons confusion for decades. There are a lot of policies. You'll have a lot of documents. There's also one that includes language about spark testing. Why is the spark test important for a taser? Members of the jury, spark tests are important because they rebut any claim by the defendant that she spends more time using her gun than her taser. The point of a spark test is not only to check to see that it's working, to make sure your taser is functional, but it's also to put your hands on it. It means you have to pull it out, hold it in your hand, put your finger on the trigger, and test fire it every day you work, before every shift. That's the expectation. that means that every Brooklyn Center police officer should have their hands on that taser every day on the job. Every day she was supposed to practice using that taser. Now, the defense may refer to this as an unfortunate mistake or a tragic accident, or that because the defendant didn't know or didn't realize that she had a gun in her hand, that this is somehow an accident and not a crime. That is simply not the case. It's just plain wrong. Accidents can still be crimes if they occur as the result of recklessness or culpable negligence. You're not going to find the word accident or mistake or error anywhere in your jury instructions because it's not a defense to the crimes charged. An accidental killing is still a crime if the defendant's actions are reckless or culpably negligent. And the defendant's failure to recognize she was drawing and handling and firing her gun, despite hours and hours of training, despite years and years of experience, despite the clear differences between the two, and despite the opportunity to change course and correct, and despite all the warnings and cautions against doing this very thing, is part of what establishes the defendant's recklessness and culpable negligence in killing Daunte Wright. On the subject of errors or mistakes, you heard from Dr. Miller that action errors that we sometimes see are those things like misdating a check or entering the wrong password. And as I said, members of the jury, drawing and firing the wrong weapon is not the same as misdating a check. And doing something for 26 years does not automatically override another thing you've done for 19 years. There was a lot of discussion from Dr. Miller about the medical field, the field of aviation, and how errors can happen. But anyone can be prosecuted for their criminal negligence. Anyone can be prosecuted for reckless driving or child endangerment. And anyone can be prosecuted for reckless handling of a firearm. The same applies to police officers, just like anyone else. The people who do the job right should not be judged by those who do it wrong. And this case is about only one person's conduct. It's about the defendant's actions in killing Daunte Wright. It's about her recklessness. It's about her culpable negligence. The professional world is based on the principle that instruction and training and practice and prevention, that those things work. And that people have to be responsible for following their training and being aware of risks. That's what training's for. You can rely on your common sense. Training works. Human nature did not kill Daunte Wright. The defendant did. The defendant told Dr. Miller, "I don't make mistakes. Take that for what you will." She also told him that the car was running. The car was on. So she knew she was firing on the driver of a vehicle, which makes any decision to use the taser even more dangerous and more risky. She also told Dr. Miller that Officer Lucky and Sergeant Johnson backed away. They disengaged when she said taser, taser, taser. So apparently, that's all it took to call them off. And once they backed away, there would have been zero risk of anyone being dragged. There would have been no need to fire any weapon at all. no matter what she may or may not have initially perceived. In this case, and in her career, the defendant consciously and intentionally took on a very important and very serious responsibility. She chose to become a police officer. And she failed in that responsibility. She betrayed her badge, and she betrayed her oath. She betrayed Daunte Wright and her fellow officers too. And her conduct was criminal. This case is not about Daunte Wright. Daunte Wright is not on trial. He's not the reason we're here today. So whether or not you agree with his decision to flee is not what this case is about. He's not the defendant here. This case is about Kimberly Potter. We're here today because of her conduct, her choices, and her actions. We're here today because she killed Daunte Wright. But this case is also not about the defendant's law-abiding or peaceful nature that you heard about. It's about what she did on that day, on April 11th. It's about her rash and reckless conduct. You heard from a number of people that she's a good person or a good cop. You heard from a lot of people in her police family. Members of the jury, good people can commit crimes. Police officers can commit crimes too. And it should come as no surprise that the defendant had a reputation for being law-abiding before April 11th. She was a police officer, and that is the expectation. And just because she didn't kill people for the first 25 years of her career does not mean that no crime occurred on April 11th. This case is also not about whether the defendant is sorry or whether she's remorseful. Of course she's sorry. Of course she feels bad for what she did. There's no dispute about that. But that has no place in your deliberations. Your duty, members of the jury, is to decide this case without sympathy. And you have an instruction on that. And without considering in any way any possible penalty or punishment. You've got an instruction on that too. Be fair, act honestly, deliberate without prejudice, bias, or sympathy, and without regard to your personal likes or dislikes. This case is not about remorse. It's about the defendant's actions in shooting and killing Daunte Wright. And you were all selected for this jury because you said you would follow the court's instructions and apply the law. That's your only job in this case. That's what you're here to do. In this case, the defendant made choices, a number of choices, and those choices killed Daunte Wright. She chose to engage, she chose to use force, she chose to escalate, she chose to draw the weapon on the right side of her duty belt, she chose to reach her right hand down to her holster, she chose to ignore the feel of that holster, she chose to ignore the weapon in her hand and how it came out of the holster, she chose to put her finger on the trigger, she chose to ignore the feel of the trigger. She chose to ignore the feel of the grip. She chose to ignore the weight. She chose to ignore the color. She chose to ignore that there was no display and no lasers and no flashlight of this gun that was in her right hand, right in front of her face, with her right index finger on the trigger. aimed directly at Daunte Wright. She chose to pull the trigger. She chose to fire. She chose to disregard her training and to disregard the cautions and the warnings and the risks. She knew she had both weapons on her duty belt. She knew how to get it right, but she failed to get it right. She failed Daunte Wright. The defendant alone is responsible for her choices and her actions. Daunte Wright did not cause his own death. We're here because this was entirely preventable. It didn't have to happen. It was a tragedy of her own making. And it's not just a tragedy. It's manslaughter. That she was an officer does not make it okay. That she was on duty does not make it okay. That she shot him with her service pistol does not make it okay. Her actions were rash and reckless, and what she did was wrong. We trust the police to safeguard lives. We trust them to do that until they don't. The defendant shattered that trust when she shattered Daunte Wright's heart. She chose right instead of left. She chose wrong instead of right. She chose her gun, and she shot and killed Daunte Wright. Thank you.
All right, members of the jury, we're going to take a 20-minute break. So we'll reconvene in 20 minutes. Please be seated. Okay, counsel, there's an error in the jury instructions that I think all of us missed. It's the instruction on evidence of character. It says that in this case you have heard evidence as to the general character and character for honesty of the defendant. We need to correct that because I'm wondering, I think that instruction should be reread to the jury and corrected on the jury instructions that go to the jury. What I was thinking of doing is that I'm going to be giving the jury additional instructions on the laptop and the evidence, returning for information and notes. I think I should reread that instruction, and I guess I'd like to hear your thoughts as to whether or not I tell them that there was no evidence of character for honesty in the case as well.
Peacefulness, right, Your Honor?
Pardon?
Peacefulness?
It was peacefulness and abiding by the law. There was no evidence, and I did not allow any evidence of character for honesty. Ms. Eldridge or Mr. Frank, do you have any thoughts on that?
Your Honor, we recognize that error in the instruction that we never took out, and we would propose that the court just take out "and character for honesty." Just leave and just omit that phrase and advise the jury that it's been updated and read it to them again.
Okay.
That's,
What you should do is just say, in terms of the character evidence, I want to read it to you again, so you don't emphasize the mistake. And say that the character for law-abiding is the peacefulness of the defendant, and then leave it at that. That's what you should do.
I think I should do a little bit more than that. I'll think about it over the break, but my thought is that I should tell the jury that the instruction that I read to them on character evidence was wrong. There was no evidence regarding Ms. Potter's character for honesty. And then reread the instruction.
with peacefulness in, Your Honor?
I'm not.
What's evidence of peacefulness?
You'd have to reread the instruction and say character for peacefulness and law-abiding. That's the correct instruction. So we want that in. You can't just take it off and then give them the impression that honesty doesn't matter.
Okay, is there any objection to that from the state?
Actually, I think we should just leave it at general character, but I would oppose having the court say there was no evidence of character of honesty. I'm afraid that calls out, may cause them to wonder why. So I think it's better not to call out what we've taken out. And I think the defense probably agrees with us on that. Otherwise, Your Honor, the state doesn't oppose putting in what the defense suggests about what the actual character evidence was limited to by the court, peacefulness and law-abiding.
Okay. All right, so I take it that everybody agrees that I should tell the jury that the instruction on character evidence was erroneous and that I'm going to reread the instruction to them. In this case, you have heard evidence as to the general character for peacefulness and being law-abiding of the defendant. You should consider this evidence. Okay. And then there was also a typo on page 9. I read it right, but on page 9, paren 3, or should be an of. Okay, so very minor. All right, let's take a break, counsel.